in the state of Florida Department of Children and Family Services.
Please, the court. Good morning, Your Honors. I would like to reserve 7 minutes for rebuttal. If I could, Your Honor, I don't know, in your dialogue or your monologue there, you did not specifically request, I don't know if I get a 1 minute warning, or will you do that, or just tell me it's time to be quiet?
You're going to make me remember when I was
I will tell you that I will try to let you know when you have a 1 minute warning. I assume that's before your final time expires or before I tell you that you're going into your reserve time. We'll clarify this ambiguity. We'll use a linguistic canon of a construction.
If I could have a 1 minute warning at the 12-minute mark, Your Honor, I would appreciate it.
Okay. We can try to do that.
Thank you, Your Honor. If it pleases the court, my name is Tim Beasley, and I'm here to represent the appellant in this case, who was the maternal grandmother and the intervener in this case, in the dependency case, and she intervened in that case for the purpose of subsequent adoption pursuant to statute section 63082, subsection 6 of the statute. The case raises two issues today that happened before the trial court. I raised it before this court today, as to whether the trial court committed a fundamental error when, in its order, and that's important in this case, in its order, it denied adoptive placement with the grandmother by, number one, using information in the order that was never disclosed to the grandmother before the order was issued. And the second contention that we would have, Your Honors, today is that by using this non-disclosed information and not the actual evidence that was presented at the motion to intervene hearing, that the court committed an error in denying the grandmother placement of the child at that time period. In other words, our contention today is that the court order relied upon facts that were not in evidence and facts that were not disclosed to the grandmother before the hearing or even during the hearing in this case. And they were only disclosed to the grandmother in the actual final order. And that was a fundamental error, and that's what we're asking the court to rectify today. So therefore, we're asking this court to reverse the trial court decision and using only the evidence that's in the transcript that happened at the noticed hearing on the motion to intervene, either to order the court, remand the case and order the court to place the child with the grandmother, or in the alternative, to set another hearing in this case in which, if there's going to be opposition on behalf of the department and the guardian litem and or the court in the case, that they disclose information and evidence in this case to the grandmother before that hearing, so they have the opportunity to discover, prepare, and call their own witnesses or cross-examine any kind of evidence going to be used against them in that case. This case is kind of similar to Adoption Miracles. And in our briefs, Adoption Miracles was cited for jurisdictional purposes. In other words, appealable non-final orders and these and denials of motions to intervene. However, in this particular case, Adoption Miracles in that case did note, it is similar to this case, in that there was a denial of motion to intervene in that case because the intervener did not have access or information to the dependency court file. And it's interesting to note that both in statutory sections 390150 and 51 are definitions in the dependency statutes of parties and participants. The grandmother was neither in this case. She was, besides having the placement of the child for a week and the child removed from her care, she had no information what was going on in the dependency court hearings. She was excluded from the dependency court hearings, and therefore she had no knowledge of this information to be able to prepare for these things at the hearing that we had on the motion to intervene. So again, we're asking the court to do today, and I want to go through this in 3 steps today. First, I do want to review the overall statutory section 630826 in this case, as well as the underlying case law decided by this court in the JT decision that shows how the application of that case, of that statute, should be applied in cases where there are private adoption, prospective adoptive parents or agencies who want to intervene in a dependency case. So first, I want to do that. Second, I do want to mention to the court about the legislative intent in these cases to promote cooperation between private adoptions and the department when it comes to dependency cases. I cite 2 statutes for the court to back that proposition up: 63022, subparagraph 5, which talks about the intent. Then also in 39802(4)D, when the department moves for termination of parental rights, it says in paragraph 4D, subparagraph 4D, that the department must notify the parents of the right of private adoption before it goes through with the dependency termination of parental rights. So those are key clues in these cases that show that the legislature is intending for more private adoptions to happen in dependency cases, but they want the procedure to be followed. And the last thing I do want to touch on, and it's probably the most important one of all in the case, is that in this particular case, the grandmother presented her case. She had the hearing. Everybody knew the hearing was going to happen. She came into the hearing. She was the only party to present evidence. If you go back to the transcript, and I challenge the court to do so, if you go back to the transcript, you will see that the only thing presented is the motion to intervene, which had the parents' consents, the preliminary adoption home study that was done on behalf of the grandmother in this case, and very much lastly, her own testimony. The only evidence that was posited against her in this case in opposition was her cross-examination. She was confronted either by documents, medical reports, adverse witnesses, nothing in this case. The court should have considered only what happened at that hearing and not other information that, quite frankly, we don't know where it came from. And we have no opportunity to do it. Now, there would have been plenty of opportunity in these cases for the grandmother to be noticed. A simple notice or request to take judicial notice of the court file would have sparked an inquiry on behalf of the grandparents in this case as to what do you mean? What is this? We want to take judicial notice of medical records with information of that case, that nature. None of that was ever done in this case. So that's what's happened. And further this argument, I do want to go to the statutory section. 63.
Counsel, before you go there, in reading some of the transcript, if I recall correctly, and forgive me as I get older, sometimes it's not as clear as it used to be when I was younger. It seems that the trial court spoke at some length during the process of this hearing, indicating a number of concerns about the child's health care, about the loss of the tubing in the ear and the like, as though that was going to be one of the issues and putting everybody on notice of it. I didn't see any further inquiry. It seemed to suggest that counsel was okay with that. You know, could you address that for me, make sure that your reading of the transcript may be the same as mine or not?
I think there were some issues. I think the court is correct. There were some issues that talked about certain general conditions. But when you look at what I itemized in the brief in this case, information that supposedly that was considered by the court, that supposedly the child had to be respirated in the hospital, a blood transfusion, and the statements that were made that the child nearly died in the court order. There was no evidence whatsoever in the transcript at the hearing that any of that happened. There was no information produced to the grandmother that any of that information happened. Her rendition of the events had none of that information in it whatsoever that any of those things transpired or happened. Her rendition of the events, the child got sick. She took the child to the doctor. The child said the child needs to go to the hospital. She took the child to the hospital. That's her rendition of the events.
Well, that's a pretty, I mean, you're focused on that one statement that the child nearly died. Now, this child was taken out of NICU the very day it was released, flown to California with the grandmother, apparently aspirated some food because of an NG tube came out and affected its ability to ingest food, got a severe case of pneumonia, was taken to the emergency room literally upon arrival back in Tampa. I don't know that that's a terribly illogical conclusion to come to for this newborn who's born substance addicted, taken out of NICU, taken across the country, ingests food, develops pneumonia, and is rushed to emergency room. I don't know. I'm a layman. That sounds like nearly died to me.
Well, I understand, Your Honor, and I understand you're fixating on that particular.
I'm only fixating on it because you did.
Yes. And Your Honor is correct that the child did get sick, and the mother did take the child on the airplane. In fact, the evidence that was used concerning that during the hearing was the evidence that was actually in the home study, the preliminary home study that the grandmother commissioned for the motion to intervene in this case.
And all of which your client knew. There's not a piece of information that you related first that I embellished a little bit that your client didn't already know.
The information that's in the brief that was in the court order in explicit detail That information was, my client did not know. That information was not known by counsel. That information was not known to me. And quite frankly, Your Honor, there are cases where sometimes statements get made at hospitals or things like that. They get taken down, they get admitted into evidence, or get used, admitted into evidence, get used at dependency hearings. And in those particular cases, they all of a sudden become evidence. There would have been a situation where at least had those specific medical records where the child was going to die and the child did all these things that were being alleged and actually used in the court order, that the mother would have been able to know that, or counsel would have been able to know that before we went into the hearing. Actually, in fact, that should have been produced at the hearing. I mean, what we're talking about here is this maybe, and I understand what the court's concern is, but I mean, it would have been very easy to move forward and submit that information and evidence at the hearing. The hearing was the place to do it, Your Honor. That's the critical key. That's the critical key when it comes to proper notice and proper evidence in an evidentiary hearing determining placement. That time period is when the information should have been placed in the record at that particular hearing. It was never done for the purposes of this record. It was never placed in here. And while the grandmother may have had some information, anecdotal information that she ascertained in the hallways or through other people, she was not permitted to sit in on these dependency hearings. So she had no knowledge exactly what was being said. Some things were being said about her because she wasn't able to have continued custody of her grandchild. But to say that she knows all the facts, all the legal operation was happening in the court, what the court's findings are going to be, without her having the access to being a participant or party in a dependency case, it just didn't happen. She didn't have that information, Your Honor. So the hearing would have been the proper place to raise those arguments at the time and say, well, the court's going to sit there, the trial court could have said, we're going to sua sponte, admit into evidence, unless there's an objection, the medical records for this case that showed what they actually used in the court order. And if the court goes back and looks at the court order again, and looks at even my brief, the initial brief in the case, and I challenge the court to do so, those findings are explicit. They're not just, and I did just use the phrase that a child nearly died. That was used several times. But the bottom line, if you look at the evidentiary things that were used to determine appropriateness of this case, they're quite explicit. And they were never produced in the evidence at this hearing whatsoever. And that's the reason for the fundamental objection in the case. That should have been evidence that we should have known about. It should have been produced to us that we were hampered in not receiving as being an outside intervener in a dependency case.
To follow up Judge Morrison's question, if the trial court engages with counsel and says, I'm concerned about this and I know this stuff is in the file, is that sufficient to place you on notice of the possibility that the court is going to consider that evidence? Because there's a statute, at least in part in Chapter 39, that suggests the trial court may use reports, and the trial court may say, well, I can do that under Chapter 39. I understand there's a phrase at the back end of the statute, may be received. But just assume that there's a potential error of law that the judges maybe say, I know I can do this, and I'm telling you, and it seems to me everybody is agreeing, you know, and there's nothing placing you on notice of it that you should disagree with the trial court's intention.
Well, there's two things on that, Your Honor. Number one, usually it's use of records that have been either admitted before at a prior hearing, which it may have been in this case, I don't know.
And I understand that concern.
Or it may have been a situation where there was a transcript from a prior hearing as asked to be admitted. Either way, that evidence, that transcript, that is going to be noticed, is going to be produced to the other party, so they'll have access to it and be able to prepare for it when it comes to their hearing. Now, here's one thing that the trial court did do, where the appellant were coming in here and we're complaining about the trial court. But the trial court did move quickly. Thank you, Your Honor. The trial court did move quickly in this particular case to try to set the motion to intervene, which the statute requires in subparagraph 6A, which says once we file the motion to intervene, once the consents are there, and once the preliminary home study is there, then we set the hearing. And so it set the hearing quickly. But that also may have been part of the problem in that the entire dependency case file was unknown to us and then used in the order. And that is the specific objection that we have in this case. If the court goes back and looks at the transcript, I would again state to the court that the preponderance of the evidence shows that the placement would have been appropriate with the grandmother. The court could have put in all sorts of requirements and restrictions as to initial placement, as to visitation, as to courses or any other kind of services that may have done. The court could have done that under the guise of best interest and appropriate placement at that time period. So what we're asking the court to do again today is to, again, based upon the fact that these facts were not known to us, we're asking the court to go ahead and either weigh if the evidence was appropriate as of the hearing and grant a relief requested placement with the child, or in the alternative, to grant a new hearing in which the information to be disclosed to be used against us is actually disclosed, so we have a chance to learn of its discovery. Thank you, and I reserve the remaining of my time, Your Honor, for rebuttal. Thank you today.
May it please the court. Good morning, Your Honor. My name is Weidner Law. I'm with the Attorney General's Office, and I'm here on behalf of the Appellate in the State of Florida Department of Children and Families, and I will also be speaking on behalf of the Guardian Ad Litem program, and General Collins here, Your Honor. Your Honor, just to touch on the last point that the appellant mentioned regarding proper notice of what was going to be discussed at this hearing, I'd like to direct this court's attention to the record, page 49, which is the order that was issued on January 22nd, 2013, which specifically notes the persons who were present at that hearing, and the maternal grandmother was noted as a person present at that hearing. So to say that there was absolutely no notice of the testimony and the proceedings on January 22nd, 2013 is not supported by the record. Additionally, Your Honor, I would submit to this court that the grandmother was on notice because everything that was involved in those what happened in January involved her actions. It involved she was there for the child's medical issues, she was there for the trip to California, and she knows the child was subsequently hospitalized. To say she had no knowledge of the specific details ignores the big picture of what is in the child's best interest.
Well, let's look at the micro picture. Let's assume that one of the documents that the trial court went through was a medical report, perhaps done by a nurse on duty, that says the child was near death. Grandmother's not going to be present at the time that report's propounded, doesn't know the qualifications of the author of the note, may not even know who it was, and might have liked to respond by cross-examination or by furthering her testimony. I think that tends to be the thrust of appellant's argument. I may be mistaken. What is your response to that?
Well, Your Honor, as to if a specific report was admitted into evidence, Your Honor, the court already had a standing order finding that this placement with the maternal grandmother was not in this child's best interest. And really the points of the order that appellant is taking issue with involve the procedural history of the order, which goes into the actual details. As to respond to your question regarding whether that specific report, which she didn't have the opportunity to cross-examine, that might be an issue before the court. However, I would like to submit to this court that even in the case law cited by the appellant in the initial brief regarding when a specific report was not admitted into evidence or was improperly admitted, it still amounts to harmless error because the entire context of the proceedings really focuses on the big picture of what is in the best interest of this child. And the best interest of this child is served by protecting the well-being of this child and ensuring the child's health and safety and welfare. This best interest is not specifically defined within Chapter 39 or Chapter 63. And I think the reason for that is because it needs to be flexible and it needs to take an approach as to each particular child. In this case, we have a medically needy child who is already in the placement of the maternal grandmother and had to be removed from the grandmother less than a week because the grandmother neglected the child's medical needs, took the child on a cross-country flight to California, and didn't seek medical attention for the child when the feeding tube fell out. If you're both just focusing on solely what Judge Morris pointed out in the appellant's case, those are the omissions of the grandmother. Those facts alone clearly indicate that the grandmother is not protecting the well-being of this child. She's substituting her own judgment for that of the child's doctors. She didn't even consult the doctor before she took the trip on a cross-country flight. And when she came to the hearing in June of 2013, after being present at the January hearing, she did not submit anything had changed since the prior hearing. She did not say, Your Honor, I've met with experts and they don't believe the child was in severe distress. She did not say, I understand the error of my ways. Rather, she submitted to trial court that she understood the trial court's concern and that she did nothing wrong. It could have happened in California, it could have happened in Florida, and that she would still believe that her judgment is on par with that of the child's doctors in assessing this medically needy child's needs. And to further the point on whether or not the concerns of the trial court were brought to every party's attention the moment the hearing started. The appellant did not object. The appellant did not say, I have no notice of that, there's no facts and evidence. Rather, the appellant proffered to the court, I understand and the grandmother would like to testify regarding that incident. It is the appellant's duty to preserve an error before the trial court for purposes of appeal. If the appellant did have an objection, that was the time to make it, to say, Your Honor, I'm not on notice of that. I don't know exactly the details of what happened. I object to that being considered, or ask for a continuance in order to get time to prepare for it if that was going to be the focal point of this placement hearing. The appellant did not do that. The appellant is now also claiming errors with the specific order. However, the appellant never even took issue with the order before the trial court. There is case law out of the first BCA from 2013 and versus BCF, which states that statutory deficiencies within the order should be addressed by a motion for rehearing and give the trial court the chance to correct the order before seeking appellate review. The appellant did not do that in this matter and rather sought appellate review immediately.
Do you know if this court has weighed in on that rehearing motion? Because I remember there was a while back a big discussion in the context of dissolution of marriage. I think there was a concurring opinion by Judge Silverman on that, but I think so far, at least in the divorce context, I'm not aware that we have agreed with our sister court, the first, about the necessity of a motion for hearing. I don't know if we've addressed this one. I don't think we have in this context.
Correct, Your Honor. I'm not aware that you have agreed, and I'm also not aware that you have not agreed with the first district court of appeal in terms of whether that motion for rehearing is required. But I do submit to this court that this long-standing principle of appellate practice that the appellate court will not review an issue of the trial court order, a perceived error of the trial court, if the trial court has not even been given a chance to correct the error or has not issued a ruling on the error. Here, by all representations of the record and the transcript, it appears that everyone was on notice that the focal point of whether placement of the maternal grandmother was in this child's best interest was based on the January 2013 incident where the child had to be removed from the grandmother's custody and hospitalized less than a week after placement with her.
You raised another question, or at least implicitly with your proposition, and that is, were we to accept an invitation to rule on that one, be kind of hard-pressed to do and say, I'm sorry, we're going to adopt the rule by the first, but we're going to make it retroactive as well as prospective, because it wouldn't have been the law at the time that counsel was arguing, at least from our district.
I understand, Your Honor. However, I still believe that this trial court is inclined to give, or is typically inclined to give trial courts deference and at least give them the opportunity to fix what their perceived mistakes are before they will weigh in on the issue.
We have 3 former circuit judges on the panel. We give trial courts a lot of deference.
So to sum up, if we are to look solely as narrowly at the statute as the appellant requests and just focus solely on the homesteading before the court and the grandmother's testimony, clearly it was not in the child's best interest to place with the maternal grandmother. As I stated, there is no specific definition of best interest within the statute. However, this court has, the best definition I could find was from this court in re S&W that the appellant mentioned in footnote 4, which states that the best interest analysis determination that requires that the birth parent's choice of prospective adoptive placement is appropriate and protects the well-being of this child. Clearly, the grandmother's admissions, the grandmother's testimony regarding her actions, and the grandmother's inactions, and the grandmother's still belief that she did not do anything wrong at that time, and no change in circumstances since January when the child was removed from her custody, clearly is enough for the trial court to find that this grandmother is not appropriate and would not protect the best interest of this child.
Thank you, counsel. As a point of information, you have 6 remaining.
Thank you, Your Honor. And in rebuttal, I would tell the courts that, again, much is made about the appellant's duty to preserve error in the answer brief and argument you just heard by 30 minutes. And I would say to the court several things. Number one, when you are an intervener in a dependency case, you are moving forward into the dependency case based upon the requirements of the statute. And that was brought up in the specific hearing, which is to file the motion executed with consent, so with executed signed consents, and with a preliminary home study in those particular cases. When that's filed, if there's any objection to the actual home study provider or any methodology behind it or the consents themselves that can be raised, they weren't raised. So you get to the appropriateness of the placement in the best interest of the children. Now, 6E doesn't not define best interest in and of itself. It says that one part that should be required in considering best interest is the parent's interest in this case when they sign the consents. Again, they were signing consents, in this case, to promote a relative adoption in this case. And 6E basically said that when it considers transferring the custody in best interest, the court shall consider the rights of the parents to determine an appropriate placement for the child, the permanency offered, and the child's bonding with potential adoptive home the child's residing in, and the parent's interest in doing so. So there needed to be considered in that weighing factor, but that was not weighed.
The toughest part about this case is the result is counterintuitive. And it was counterintuitive by a very experienced trial judge who obviously had great pains with this case. Took the case under advisement, wrote a very long and carefully worded order to justify why she didn't place this child with the child's grandmother, who was a registered nurse. That in and of itself makes you say, wow, this should be a perfect placement under all other scenarios. And this judge clearly struggled with this case. And unfortunately, this scenario, which is I've recounted and you've recounted, obviously didn't weigh well with the grandmother, who, because she is an RN, should have known more than anyone what she put that child through was dangerous and reckless. And that's, unfortunately, those are the simple facts of this case that you just can't shake out of your head.
The problem, Your Honor, is for the motion to intervene in that part of the case, with all due respect, Your Honor, it's not the simple facts of the case, because they were not presented at the hearing. They were never presented at the hearing by DCF, they were never presented by the GAL, they were never taken notice of by the trial court. So when the intervener comes in there as a legal matter for evidentiary hearing, the only evidence that got presented was the mom's statement and the mom's preliminary home study. That's it. Outside of some cross-examination, that was the entire amount of evidence that was presented. Now, the court did struggle, and the court wrote the trial court wrote a long opinion in this particular case. And a lot of thought went into that opinion. And I'm not casting any aspersions upon the trial judge. I'm not, Your Honor, with all due respect. But in this particular hearing, that evidence should have been presented. The grandmother should have been confronted with that and had a right to cross-examine it and present her own counter-evidence if she had any counter-evidence. We went into a motion for it to intervene with no notice whatsoever that this particular evidence is going to be used against us at this particular hearing. We came in and presented our witnesses, put in our information.
I imagine you couldn't have notice of that. That was the whole basis upon which the child was removed from.
The child was removed according to the mother. There was information that the child was sick, Your Honor. Yes. The child got sick on the trip. They didn't know exactly when the child got sick on the trip. It was during the trip when the child came back. There was a dispute as to that. If you look in the home study addresses the issue about the trip. That was only evidence at the hearing about what happened.
But as a medical professional, wouldn't the grandmother know the nature of the inquiry? I mean, it's peculiar that,
yes, sure.
that she knows the feeding tube fell out. She knows there's feeding issues. She knows that this child is vomiting. It seems to me she testifies at the hearing. She's got the perfect opportunity to explain what happened and why, going forward, that shouldn't be a concern, that she should be entitled to take this child. And the judge heard her, listened to her, watched her, observed her, wrote pages and pages about her. It's just, I'm hard-pressed to see where the prejudice lies when she, of all people, should have known what happened and what the nature of what she was going to be asked was going to be about.
Well, again, the issue, and I agree with part of what the court's saying, and the mother did testify that she was trained RN,
right.
And one of the reasons that she did take the child to California, she thought she could take care of the child when she went to California.
Did she think that she had the right to take the child to California? She just thought that was no problem?
Actually, she did testify to that, and that was actually in the home study, because the child was taken to Hillsborough and placed in Pasco County. As she testified, she signed a 10-page piece of paperwork that was not given to her.
And she left the child in the caretaking of someone who nobody knew. Nobody had a chance to do any background on him.
And I understand that.
It was her boyfriend, no longer is her boyfriend.
Right.
I mean, it's just, it's hard to reconcile her training and her degree with her conduct. And I think that's the problem. And now we're asking us to reweigh.
I'm not asking you to reweigh any facts, Ron. That's the key here. And everybody seems to want to, and I understand why. We want to reweigh the facts. I'm not asking you to do that. I'm asking you to look at the transcript and what the testimony was, what the actual evidence that was submitted.
I'd like to give every opportunity for a grandmother to adopt a child as opposed to some foster care system, but I don't see, I'm not convinced yet.
Okay.
You got about 2 minutes to sell me.
Really?
Okay. Again, Your Honor.
Or does he?
Do I?
Judge Black has spoken.
Well, I appreciate the extension of time, I think, Your Honor, to be able to tell the court why, again, what the fundamental issue is here. The fundamental issue is how this case comes apart, comes together. Okay. Again, you have a dependency case, and I would submit to the court that as a legal matter, the grandmother is not a part of that case. She's not a party or a participant in this case whatsoever. And if she appears to one hearing, the fact that she's going to know everything that happens in one hearing is not straightforward. Secondly, you've got evidence in medical records where the court or the state is saying one thing and the grandmother is saying another. Okay, so she doesn't have access to that information to rebut her. This is information. The information the court is arguing is information that should have been produced at the hearing. It was not produced at the hearing, quite frankly. And she should have had the opportunity to confront those folks, because a lot of times this information came in a dependency case and these accusations were made against her. She had no opportunity to confront them in the dependency hearing because she was not a party to it. That's the essence of the argument. It's not to reweigh the facts.
The hearing that was scheduled was a two-pronged hearing, was it not? A motion to intervene and for placement?
No. You don't know, Your Honor. It was a hearing under 63082. The order broke it down, and I understand why the court did that, and that's fine. If you look at your decision in JT, as well as the statutory section, that basically says when you have the requisite elements together in a motion to intervene, in other words, a consent signed by at least one of the parents, and then a preliminary home study for the adoptive parent, then you can file with the court. Once that's filed with the court, then basically as a matter of law, you're allowed to intervene. Now, will the child be placed with you or not is a question of appropriateness and best interest and testimony. And if there's opposition, or there's question in the court mind, then there has to be evidence presented as to appropriateness and best interest. And the whole argument in this case was, at that hearing, the only party to present evidence at the hearing was the grandmother, was testimony she gave in her preliminary home study. And that's what the court, in this case, I would argue, has to consider. That evidence. It cannot consider the entire court file. Why? Nobody put in evidence. Nobody placed it before the court. Nobody said, hey, I want to stand up and make
I need to tell you that the sands of time have indeed expired.
And I do appreciate Your Honor, and I appreciate the extra time. Thank you very much. And thank counsel for being here today as well. Thank you.
Thank you. Thank you both.